Thanks for joining us. You're still on the Polity's Weekend Review, of course, reaching you live from the nation's capital in Abuja. And during the week, the National Assembly Election Tribunal nullified the election of Napoleon Bali, senator representing Plateau South Senatorial District, and declared Simon Lalong as the duly elected senator for the zone. The tribunal held that the votes scored by Napoleon Bali in the February 25th, 2023 general elections were wasted votes, and he was invalidly nominated because at the time of the nomination, the PDP had no valid structure in Plateau State. And of course, with me in the studio is Emmanuel Mente Madaki, barrister, senior legislative aide to the Senate Minority Leader. Welcome to the studio.
Thank you for having me.
It's good to have you once again on the program with us. All right, now today we'll be analyzing the postmortem analysis of the Plateau South ruling, and of course, I just read one of the court verdicts. And let's start and let's just get into the nitty-gritty. The tribunal has no business with pre-election matters. This is one of what people have actually said. I'd like to get your own perspective as it regards the ruling that was made during the week.
The most important thing to understand is the fact that the tribunals are set after the elections.
Okay.
And almost always when a tribunal is set is to look at what is happening or what has happened contemporaneously during the conduct of the election.
Okay.
And so the tribunal has a limited scope to look at the activities that transpired during the conduct of the election, and the tribunal has no business, dealing with events that transpired prior to the conduct of the election.
Okay.
And where it has been shown that the person is qualified to contest the election, no any other law can disqualify the person.
Okay.
And that is why almost always it is expected that the constitutional provision that mandates a person to fulfill a certain requirement for him to stand an election is what is of paramount importance. And of course, it is insignificant for one to begin to look at other events just so that the person could be disqualified arbitrarily, irrespective of the fact that the person has complied with the requisite constitutional requirements. For instance, if you are talking about the qualification of a senator, the first thing you have to look at constitutionally, you go to section 65 and 66. Section 65 talks about the qualification of the person,
yes,
wherein it has laid the following requirements. 1, citizenship. Is a person a citizen of Nigeria? 2, the age of the person. Has a person attained the minimum age to be able to stand the elections? 3, you talk about the educational qualification of the person. They said the person must have been educated up to a school certificate level or its equivalent. And then the person must be a member of a political party. Membership of a political party is so significant to the extent that the constitution tries to, curtail instances of independent candidacy or candidature. And that is why it is expected that the person must belong to a political party. Now, narrowing it down to the tribunal's decision, it will baffle you to know that the tribunal came to that conclusion just because of the fact that the tribunal, on its own finding, came to resolve that yes, PDP had no structure in Plateau State. And the question one should ask its intellect is, was PDP having, or is PDP still having a structure in Plateau State? The question is, the answer is
sorry to break that. What do they mean by the PDP does not have a structure in Plateau State? Do we need to is there something else we need to understand as regards that?
Yes, basically, why the opposition is bothering itself with the factor or the question of structure of the party is the fact that in the year 2020 in Plateau State, something happened, internal squabble within the party, wherein the party was actually compartmentalized into two, having two factions. That is, one, Bitrus Kazi had his own faction, and then the incumbent chairman of the party, Chris Hassan, had a faction. And after the election in 2020, Bitrus Kazi, in exercise of his constitutional power or in constitutional right, approached the Plateau State High Court. And the Plateau State High Court at that point now said, okay, fine, despite the fact that this issue is an internal affair of the party, it is not justiciable. The court has no business to choose leadership
for the party. Yes,
but then the court now said, what we can do in its own wisdom, Justice SP Ghana ordered that, look, go and conduct fresh congresses in line with the party constitution and then the constitutional requirements.
Okay.
The party, in obedience to that court order, went back and organized repeated congress on the 25th September 2021, wherein the said Bitrus Kaze, who had earlier approached the court, participated in the said repeat congress, which saw the emergence of the present leadership that we have in the state. And as such, that on the 25th September brought into existence the leadership and the structure of the party at the state level. Remember, Justice S.P. Gam only ordered the conduct of congresses for state executives alone. It did not affect the ward executive, it did not affect the local government executive, it did not also affect the national. PDP has a good structure in Plateau State, solid and functional as at now, since 25th September 2021. This has actually been a subject of interpretation by the court. In 2021, one Augustine Tim Cook from Langtan North approached the Federal High Court and asking the Federal High Court through an originating summons that the candidate of the PDP should be disqualified from contesting election in Plateau State. In 2021, the decision of the Federal High Court was to the effect that, look, despite the fact that the suit as it were was started bad, the court declined jurisdiction, but then the court made an originating summons that borders on election matters. The procedure is, after declining jurisdiction where necessary, you proceed to determine the live issues in the originating summons. The court went ahead and made a finding that PDP complied with the order of Honorable Justice S.P. Gang of Plateau State since 25th September 2021, and that was why the claimant in that suit, Augustine Tim Cook, was able to participate in the Langtan North State constituency election. Okay. Now that actually has given a judicial stamp to the existence of the party structure of Plateau State, state executive. That decision was appealed against by the said Augustine Tim Cook to the Court of Appeal, Plateau State. In the Court of Appeal, Justice Goodluck, who actually delivered the lead judgment, still maintained, affirmed the decision of the Federal High Court in Tim Cook's case, and went ahead and said that the claimant in that suit was accorded fair hearing in accordance with Section 36 of the Constitution of the Federal Republic of Nigeria, 1999 as amended, that talks about giving a party fair hearing to be had. So Augustine Tim Cook's suit was properly determined on the merits and also on the preliminary objection that determined the life of the suit. Now that leaves us with the conclusion that PDP has a solid structure in Plateau State. And I know why the tribunal ventured into the exercise of saying that PDP didn't have the structure was because in the year 2022, when the member representing Basa Jos North Federal Constituency died, there was a by-election. PDP won, but then the court the tribunal in its own finding was able to nullify that election of Basa Jos North Federal Constituency, on the basis that PDP did not show before the tribunal that it has complied with orders against it. But then,
could that be said that that is what is probably standing against PDP right now in the case?
Exactly, that is the decision.
Okay.
But then there is a principle of law that maintains that cases are precedents only for what they have decided. That case cannot be precedent for what is actually happening now.
Right
Why? Now. Because the tribunal finding that time was because there was no evidence before the court. I remember the case of Augustine Tim Cook was not even before the court. It had not even happened. And then the case of Augustine Tim Cook is the latest decision that was decided in 2023. That's the Court of Appeal decision.
Okay.
But then that of Basa Jos North in 2022 actually ended in 2022, wherein the tribunal said and the Court of Appeal there was no evidence. And we are able to dissect and have a holistic look at that judgment. We discovered that the evidence of compliance, which is the fact that INEC report was not before the tribunal. This time around, INEC, being a party to the suit, was able to tender a comprehensive report in exercise of its constitutional responsibility and powers of monitoring party congresses, party primaries, finances of a party, and expenditure of a party. So, the tribunal, the INEC this time around was able to come with that report to the tribunal and say, Tribunal, you are saying there was no evidence of compliance. We were the ones that monitored these congresses.
Congresses.
This is the report. The report was tendered and admitted in evidence without any objection. Now, should the tribunal now resort back to analyzing the decision presently as constituted using the case of Musa Aga of Basa Josno constituency? That was a wrong finding. And to make matters worse, the National Assembly Election Petition Tribunal in Plateau State is one. But then the justices were 6. They split them
into panel 1 and panel 2.
Split them into panels 1 and 2.
Okay.
For administrative convenience and for expeditious trial,
Okay.
because the petitions were much. Now, panel 1 is the one that gave the decision against Honorable Napoleon Bali, Honorable Benilal, Honorable Bagos, and also Honorable Deng of Barkiladi constituency.
Okay.
Now, it will interest you to know there is only one National and State Assembly Election Petition Tribunal in Plateau State. Panel 2 agreed with the submissions of the PDP that PDP has a valid structure. And aside having a valid structure, ground 1 of the petition borders preponderantly on the fact that the candidates were not qualified.
Okay.
But then, we have it on good record that even at the Presidential Election Petition Tribunal, when the question of double nomination was raised by APM, the tribunal made a finding and said, look, the question of qualification, disqualification, sponsorship, and nomination are pre-election matters. Being pre-election matters, and that is why the 2022 Electoral Act has come up with a new vista that pre-election matters, issues bordering on nomination and sponsorship should be ventilated at the Federal High Court. Section
not the tribunal.
Not the tribunal. Okay. Because before now, in the 2010 Electoral Act, it was even a concurrent relation between the State High Court and the Federal High Court. But this time around, the Electoral Act expunged State High Court and only giving the powers to Federal High Court alone. Okay. Now, sponsorship and nomination. New Electoral Act 2022 is saying you don't have business to come to the tribunal and bother us with pre-election matters. Okay. You do not have the local standard, and of course, being a pre-election matter, it is time bound. It is only an aspirant who participated in the party primaries that has the local standard to approach the Federal High Court to say, I was a member who participated in the party primaries. And after the primaries, I am aggrieved. I am not approaching the Federal High Court to look at what happened because the primaries was actually done not in accordance with the party constitution. But that is not the scenario this time around. The tribunal in Plateau State, panel 1, now ventured to say it is both a post-election matter and pre-election matter. That, of course, with due respect to the tribunal, is the position of the 2010 Electoral Act as amended, not the 2022 Electoral Act as we have presently. So that decision was that the finding was erroneous, and it was not actually in tandem with the current reality as encapsulated in the 2022 Electoral Act. And that is why panel 2, in its own wisdom, was able to agree with PDP and say, look, PDP, you have a good case and a good defense. Number one, apart from the fact that they have complied with the judgment of Plateau State High Court, delivered by Honorable Justice S.P. Gang, which we have the evidence here. It was tendered, the tribunal admitted, and of course the tribunal went further to say, look, questions of nomination and sponsorship are pre-election matters. You have no business to bring them to us. We have a limited scope, and our scope is to look at activities or issues that transpired during the conduct of election. Was there ballot box snatching, ballot box stuffing? Were there elections cancelled in other places, or were there infractions or other issues that militated the conduct of election in other places that led to disenfranchisement of certain people? That is what the tribunal has powers to actually determine, but not taking them. And the tribunal panel 2 now said, look, you cannot bring this one here. You do not even have the local standard, even if it was even a post-election matter. It is only a member, not just an ordinary member of the PDP, an aggrieved member who must have participated in the primaries that has the local standard to ventilate this grievance in respect of issues relating to nomination and sponsorship.
And
the law is Section 84 and then Section of the Electoral Act, Sub 14 and Section 285 of the Electoral Act says after the primaries, the aggrieved party has only 14 days within which to approach the tribunal. Once the Federal High Court, once you do not approach the Federal High Court within 14 days, it becomes statute barred. That is, it is cut off by the statute of limitation.
Okay.
So now panel 2 now agreed that PDP, apart from compliance, PDP has solid structure. PDP, the matters, issues that they're actually raising in respect of non-qualification are actually pre-election matters, nomination and sponsorship, and throughout their petition, they kept using nomination and sponsorship. Nomination and sponsorship. Those are pre-election matters. And the tribunal panel 2 now gave all her judgment, dismissed all the petitions against PDP. Now look at the crisis. The same tribunal, 2 panels giving conflicting decisions.
Exactly.
Panel 2 is saying PDP has complied, these are pre-election matters, and all the 7 judgments delivered by panel 2 were delivered in favor of PDP. But panel 1 this time around is now saying PDP has no structure, relying on the case of Musa Aga against Adamu Alkali, which happened in 2022. And it was 2021, but it was actually decided based on the 2010 Electoral Act, which has no business in the present election. But the panel 1 now used that decision as a precedent. That case cannot be precedent for the present situation.
So speaking of precedent, shouldn't we be looking at where we have panel 1 and panel 2 having a synergy? Because in this case now it looks like, oh, there are 2 other cases and there are 2 different cases, even though it's one case but 2 different verdicts. Now what is going to be the outcome on the long run? Panel 2 has come out to say, oh, PDP has no issue. Then panel 1 is saying, oh no, we're standing on this particular verdict. Now moving forward, I want to talk about problems and of course prefer solutions. Does this mean the judiciary has been compromised? Are we supposed to look at something else? Because now we've of course said eyes on judiciary, all eyes on judiciary, of course. Well. Now what does this mean for the Nigerian judicial system?
It is actually a very pathetic and lamentable situation that a sacred institution like the judiciary should be reduced to become a subject of mockery and serial interpretations by people out there, which is not supposed to be. For heaven's sake, we have one tribunal in Plateau State. The panels are for convenience. It is expected that the 2 panels should synergize, because it will interest you to know all the petitions filed against PDP in Plateau State, especially the ones filed by the APC, contain only one ground, which is actually what they are anchoring on. They are not saying they won election, but they are saying all the votes that were actually accredited or allotted to the party that won should be declared wasted votes in a democratic dispensation where it is a government of the people, by the people, and for the people. It will interest you to know further that the ground of the petition of non-qualification contains 1, the same ground, the same facts, the same particulars. The evidence laid in proof of that ground 1, in respect of all the petitions filed by APC, the evidence is the same. The documents are the same. The exhibits are the same in all the petitions. Both the ones in panel 1 and panel 2.
So why do we have 2 different results?
Exactly. That is the problem, which is not supposed to, that is where we are. The lamentable stage where we are is the fact that there was no synergy between panel 1 and panel 2. And it will interest you to know that panel 2 started dishing out her judgments. And it was almost 2 weeks later that panel 1 now started dishing out the judgments. So panel 1 had the privilege of reading the drafts and actually listening to the judgment of panel 2. But then panel 1 now chose to go on a frolic of its own and began to give decisions just to, I don't know, whether to intentionally discredit the effort of panel 2 or for whatever reason that is best known to panel 1.
Okay, so what's the next step now that these two panels have, of course, come out with two different verdicts? What's the next step now?
Well, the next line of action now is decisions of courts are only challenged and reviewed on appeal.
Okay.
And it is now incumbent on the Court of Appeal now to look at these decisions and apply the principle of...
But you have to agree with me that this decision is not a decision you see every day in Nigeria. I mean, two different panels coming with two different verdicts. That's new to me, if you ask me.
Exactly, it is actually new, because the moment the same tribunal begins to give, or the same court begins to give different decisions, you know, it robs the law of its substance and the feature of predictability.
Yeah, that's correct.
Law is certain, law is predictable. Where these features are taken away from law, of course, what you are trying to now breed is a state of anarchy where survival will be of the fittest, and of course, anybody can wake up and give a decision based on his whims and caprices. And that is why every lawyer will tell you there is the principle of stare decisis. Stare decisis in the sense that judicial precedent, where there are decisions of a superior court, a lower court is bound to apply that decision. And that is why it will leave you with the fact that the case of Basa Just Not in 2022 went up to the Court of Appeal, wherein the Court of Appeal said there was no evidence of compliance. This time around, Augustine Tinkook still went to that same Court of Appeal. Remember, the other one was in 2022, but then this Augustine Tinkook was decided by the Court of Appeal in February 2023. Now, is the latest decision in respect of the Plateau State structure, is the latest decision in respect of the Plateau State executive. And then, if the tribunal should be mindful enough to look at those decisions, the tribunal is bound to follow the latter in time. And the latter in time is the one decided in 2023. That's they have validated the position of PDP in Plateau State. And so the Court of Appeal has an onerous task now to apply the principle of severance. Now severe these two judgments and see which one is in tandem with the current and extant position of the law. And to me, it's the decision of panel 2.
Is there anywhere in the constitution, I mean, I've read them, but is there anywhere in the constitution where it says that we can have two different verdicts and then these two verdicts can be submitted to the higher court and of course they decide on which one balances?
Sadly, that is just the procedure by hierarchy of courts. The tribunal is set up. You know, the tribunal, stricter sense, or in the real sense of the word, is not a court. It's just set up for administrative purposes to look at infractions that happen for a particular purpose. And so, the panel 1 cannot begin to say, no, panel 2, bring your judgments, let us review those judgments. No. It's only the appellate court that has the power to review the decisions of a lower tribunal or a lower court. And so, our hands are tied now. But I know definitely justice will be served. We have not lost hope in the judiciary. I am a lawyer. I believe in the workings and workability of the judiciary. And one thing we must stand up against is to fight anything that will breed injustices. But I know as well that it is only when there is injustice that you value the significance of justice.
All right. Even Simon Lanlong that has been declared the elected senator for the zone is equally a minister now. What happens after that? If eventually the higher court, of course, declares him as the sitting senator, what happens? He's a sitting minister already. He can't hold two positions at the same time.
Well, he cannot. He has to choose. You remember when the president invited Femi Gbajabiamila to become one of his advisors. You know, he had no option. Having won his election as a member House of Reps, he had no option than to actually forfeit that one. You cannot be in two places at the same time. Constitutionally, in fact, even when you leave as a member of House of Assembly, House of Reps, the one of the grounds upon which you can cease to be a member is when you are elevated from that actually seat to another seat. So obviously you have to lose one at the end of the day.
Okay, speaking about governorship polls and the verdicts, where we've had one in Nasarawa where the PDP has seeked the annulment of Governor Sule's election, and it looks like we're going to have lots of back and forth. Do you think most of the sitting governors should actually be on seat when elections are taking place, or they should have left the seats? I know it's not possible for those seats to be empty, of course, but then it looks like there's a power of the incumbency. Yeah, incumbency in most of these cases now. Is there any of this thing that can be, most of the bylaws that can be reviewed, and then something changes or something?
I think that is not only a constitutional problem, but it's also a problem with the Electoral Act.
The Electoral Act itself,
because it is only when your election or your mandate has been truncated by the court, you will definitely occupy your seat. And of course, it's one of the areas that we are looking at in terms of amending the Electoral Act 2022. Despite the innovations that it came with, there are still some lacunae which we must look into. One of which is seeing the possibility of conducting election at least 1 year to the expiration of the person's tenure.
Exactly.
So that at the end of the day, we know we have the deadline of May 29 for the swearing in and for new government to take over.
But then I think that law would only work if even the incumbent person is not actually running again for election, because of course we know how it is in our politics.
Yeah, what we're actually trying to look at is where these issues of courts going to court 180 days at the tribunal, 60 days on appeal, 60 days on appeal would have actually been exhausted
in that 1 year.
Exactly, and the coast will be clear. So that when you are just starting over, you are taking off on a very high note without any encumbrance or any, because presently now some sitting governors are quite distracted from doing what they're supposed to do to deliver to the people the dividends of democracy. Now they are fighting on how to retain their positions and how to retain their seats. But when these elections are conducted at least a year before the expiration of the person's office or before the new government takes over, it will give each and every party adequate time to ventilate its grievances. And if you look at the Electoral Act, of course, it gives the respondent upon declaration, they give the petitioner 21 days to file his petition, the respondent 21 days to file his actually or response to the petition. The time is limited. But once you give like 1 year to conduct election 1 year before the person leaves office, then give them ample opportunity to ventilate their grievances. But then the time frame should be such limited that it will not encroach or extend to the next administration.
Oh, I like the fact that you mentioned something about it affecting a certain administration. Well, some persons on the street have said, could that be said that's partly the reason why we've not seen so much coming from this new administration, because they've had to actually fight right now. They are just, it just looks like, okay, now maybe we are actually sitting very well, because it looks like they were sitting with one part of their body before, but now it looks like they're sitting where, even though most of these parties have said they're still moving forward to the higher court. Do you think this is part of the major issue this said administration has had, having to fight for what they have right now?
Funnily enough, that is the truth, because if you leave me to conclude on this, I will tell you this is the reality on ground. Because the person who is actually on the seat now, the seat is shaky, litigation here and there, several petitions and all of that. It will be interesting to know that the person will have to sit back and use all the paraphernalia of office and of course sometimes the wherewithal around him to make sure that he retains his position. And that is why getting it right, the judiciary must be strengthened to dispense justice dispassionately without fear or favor, affection or ill will. And until that is done, I'm telling you, we will be left in this quagmire.
All right, thank you, Barrister Emmanuel Mente Madaki. It's been an insightful one with you today. And of course, you said the law should be predictable, but in this case, it was not predictable. We're looking forward to what will happen at the higher court when, of course, this parties move forward. Thank you very much. It's been an insightful
and just to add a little bit in that of Plateau State, of course, so far the governor has had about 3 petitions dismissed in his favor, remaining only one. So who knows?
Okay, we would wait for that one. Thank you very much once again. It's been an insightful one to you. All of you at home will quickly go on this break. When we return, the Polity's Weekend Review continues.